Congress look to pass a bipartisan package aimed at strengthening gun laws.
Ruled that the Constitution provides a right to carry a gun, issuing a major decision on the meaning of the Second Amendment.
Law made it virtually impossible for a law-abiding citizen to obtain a license, and justices agreed.
Tennessee just joined 24 other states in a coalition protecting Second Amendment rights.
Gun control law requiring people show a proper cause in order to obtain a license to conceal carry.
7-1. The Supreme Court of the United States just handed down a ruling this May that didn't just change one gun law. It changed 10 distinct areas of firearms regulation simultaneously, and it did it with a margin so overwhelming that it functionally eliminates any serious legal debate about what the Second Amendment protects. 7 justices agreed, 1 dissented, and the result is the single most consequential firearms decision since New York State Rifle and Pistol Association v. Bruen back in 2022, possibly more consequential than Bruen itself. I'm going to break down exactly what this means for you, all 10 changes in plain English, right now. Here's why you need to pay attention to every word of what follows. If you own an AR-15, if you carry concealed, if you've got standard capacity magazines sitting in your safe, if you live in a state with a waiting period or a red flag law or mandatory storage requirements, this ruling touches your life directly. It doesn't matter if you're in Texas or California or anywhere in between. The Supreme Court just redefined the constitutional floor beneath every gun law in the country, and the states that have spent the last 3 years since Bruen trying to find creative workarounds to keep their unconstitutional restrictions alive just ran out of room to maneuver. Every single one of these 10 changes affects you whether your state government has acknowledged it yet or not. So let me walk you through them. Change number 1 is the big one. The foundation everything else rests on. The common use standard from District of Columbia v. Heller. The principle that firearms in common use by law-abiding Americans for lawful purposes are constitutionally protected just went from a guideline that lower courts were selectively applying to a hard constitutional rule backed by 7 justices. That means if a firearm is commonly owned, and we're talking about AR-15 platform rifles owned by north of 20 million Americans, it is protected, period. Courts can no longer conduct their own independent danger assessment and decide a commonly owned firearm is too dangerous to qualify. The test is common use. The test is settled. Assault weapons bans in California, Illinois, New York, and every other state that has one are now standing on ground that the Supreme Court just pulled out from under them. If you've been following cases like Miller v. Bonta in California, that litigation just got rocket fuel. Change number 2, magazine capacity limits. Laws capping magazines at 10 or 15 rounds have been one of the most aggressively defended categories of restriction in blue states. The court applied the Bruen historical tradition test and found 0 founding-era analog for government-imposed limits on ammunition capacity. None. The founding generation did not tell citizens how many shots they could fire.
Congress looked to pass a bipartisan package aimed at strengthening gun laws.
Ruled that the Constitution provides a right to carry a gun, issuing a major decision on the meaning of the Second Amendment.
Law made it virtually impossible for a law-abiding citizen to obtain a license, and justices agreed.
Tennessee just joined 24 other states in a coalition protecting Second Amendment rights.
Gun control law requiring people show a proper cause in order to obtain a license to conceal carry.
Duncan v. Bonta, the Ninth Circuit magazine case that's been bouncing around for years, is now operating under a framework that is openly hostile to capacity restrictions. Those bans are falling, and they're falling fast. Change number 3, mandatory waiting periods. If your state makes you wait days or weeks between purchasing a firearm and actually taking possession of it beyond whatever time is needed to complete a NICS background check, that delay just became constitutionally suspect. The court was direct about this. The founding generation had no waiting periods. Citizens purchased firearms and possessed them immediately. A government-imposed delay beyond what's required for the background check itself is a restriction on the exercise of a constitutional right without historical justification.
It struck down a New York law that required a person to show a special need in order to get a permit to carry a gun.
I think their concern with Florida basically saying you can never open carry is if they have a concealed firearm.
Second and the 14th Amendments protect an individual's right to carry a handgun for self-defense outside the home.
They just want to come after your Second Amendment rights. Let's just be honest. That's what they want to do.
State Attorney General praised the Supreme Court's decision today, saying it upholds the Second Amendment.
Change number 4, permit fees. This one is huge for anyone who carries. The court applied the same principle that killed poll taxes decades ago. You cannot charge a citizen a substantial fee as a precondition for exercising a constitutional right. Permit fees that go beyond minimal administrative cost recovery. Expensive mandatory training requirements. Financial barriers designed to price people out of their carry rights. All of it is now constitutionally exposed under the same framework that protects your right to vote without paying for the privilege. Change number 5, and this one is aimed directly at what New York did after Bruen. Sensitive places. After the Bruen decision acknowledged that genuine sensitive places like courthouses and polling locations could restrict carry, New York turned around and designated essentially the entire state a sensitive place. Parks, transit, private businesses, entertainment venues, all of it. The court shut that door permanently. Sensitive place designations now require a specific documented historical analog from the founding era. The vast majority of locations New York and similar states designated do not have one. Those designations are constitutionally void.
All of those will be ready to come to the floor next week. I don't want to hear that this is hard and we're going to talk about it at some point. And
quite frankly, it's unlikely to happen given the conservative makeup of the legislature.
Need to have about banning assault rifles so that the kind of weapon that's used in mass shooting, so that that never happens again.
Change number 6, red flag laws. Now let me be precise here because this matters. The court did not eliminate red flag laws as a category. What it did is establish constitutional minimums that existing extreme risk protection order statutes must meet, and a significant number of them currently do not. The ruling requires meaningful due process before or immediately after confiscation, a clear evidentiary standard, and an expedited process for getting your firearms back, if you were wrongly subjected to an order. States with red flag laws that skip those protections are now facing viable constitutional challenges. Change number 7, mandatory storage laws. This goes straight to the heart of what Heller established, your right to keep a functional firearm accessible in your home for self-defense. Storage requirements that render your firearm inaccessible for immediate defensive use effectively nullify that right. The court said exactly that. States like California and Massachusetts, with their most stringent storage mandates, are now constitutionally vulnerable in ways that previous challenges couldn't establish.
Then we've got to have the debate and we've got to move forward on banning assault rifles like they were until 2004.
You voted for the A50 amendment. You voted to keep firearms more easily accessible to convicted violent felonies. You voted to continue the sale of weapons of war, assault weapons in Minnesota.
Politics is raising your voice. Politics is driving debate. Politics is bringing about change.
Change number 8, mandatory firearms registration. The court hit this from multiple constitutional angles simultaneously, and the result is devastating for registration schemes. Historically, the founding generation was explicitly opposed to government inventories of privately owned arms. The British colonial experience of using such inventories as precursors to confiscation was not theoretical to them. It was lived experience. Add Fourth Amendment privacy concerns and Fifth Amendment self-incrimination protections on top of that, and registration requirements are now defending themselves against a framework that is deeply structurally hostile to their existence. Change number 9, ammunition purchase background checks. California has been the leader on this one, requiring a background check for every single ammunition purchase. The court's historical tradition test found no founding era analog for it. The founding generation imposed no such requirement. Under the constitutional framework, this court has now cemented with 7 votes. Ammunition background check laws simply cannot demonstrate the historical grounding Bruen demands. And change number 10, the one that Second Amendment attorneys are calling the most structurally important of all. The burden of proof in firearms litigation has permanently shifted before this ruling. Gun owners challenging a restriction often bore the burden of proving that restriction was unconstitutional. After this ruling, the government defending any firearms restriction must affirmatively demonstrate with specific historical evidence and specific constitutional justification that the restriction is consistent with America's historical tradition of firearms regulation. The default position is now in favor of your rights. Every restriction must justify itself. That single change makes every other change on this list not just possible, but inevitable over time.
If you needed a graphic reminder of what gun violence does and ripping us apart, that is a pretty moving tribute.
Elected officials have a duty to protect us from guns. No one should have to go through what we went through at Annunciation.
The best way to honor victims isn't through symbolic prohibition of a particular category of arms, but by preventing the next attack.
All right, so let me be honest with you about what this is and what it isn't, because I'm not going to oversell this. These 10 changes are real and they are significant, but they do not automatically and immediately invalidate every affected law in your state tomorrow morning. Laws that have been constitutionally undermined by this ruling still need to be specifically challenged and struck down by courts with jurisdiction in your state before they're technically unenforceable against you as an individual. Do not walk out of your house tomorrow assuming your state's waiting period or magazine ban no longer applies to you personally. It does until a court with authority over your jurisdiction says otherwise. Continue complying with current law while the litigation wave catches up to where the Supreme Court just put the constitutional standard. Is this a total, immediate, overnight win? No. But is it the most powerful constitutional foundation for your rights that has existed in the history of the Second Amendment? Yes, without question, the framework is set, the burden has shifted, and the states that have been building unconstitutional restriction after unconstitutional restriction are now defending all of them simultaneously against a standard that 7 out of 8 justices just told them they have to meet. Here's your status check right now. Research your state's specific gun laws across all 10 of these categories. Connect with organizations like the Second Amendment Foundation, Firearms Policy Coalition, and GOA that are actively litigating these challenges. If you're in a state with aggressive restrictions, consider consulting a Second Amendment attorney who can advise you on your specific rights as this legal environment changes rapidly around you, and stay engaged, because the courtroom battles that determine how fast these 10 changes become your lived reality are happening right now. An informed, constitutionally aware public is part of what makes those battles winnable. 7-1, 10 areas of gun law changed, a constitutional statement so broad and so forceful that it will be shaping your rights long after the justices who wrote it have left the bench. That's it for today, folks. See you in the next video.